Good morning, everybody, and thank you for being with us this morning. My name is Amber Hines of WealthMerge, and I'm happy to have attorney Mark Munson with me today. Mark is a certified elder law attorney, and he practices in Wisconsin and is also licensed in Missouri and Kansas as well. So today we're going to be talking about Medicaid planning with qualified or IRA accounts. And you'll have to excuse my voice. I caught a cold last week, so if I have to turn things over to Mark at any given time, that's why.
Which is unfortunate for you listeners. You still probably have a better voice than I do, Amber, despite your
And I before we get started, I wanted to mention that if you have questions throughout the webinar, feel free to type those into the questions section of the GoToWebinar dashboard. We will leave some time at the end to answer questions if you have them. Also, you'll find a copy of the materials in the handout section of the GoToWebinar dashboard, so feel free to take a copy of the slides as well. So we're going to start out with some basic Medicaid asset and income eligibility requirements. This is pretty basic information for an experienced elder law or estate planning attorney, but I think it's important to start with this information. So if we look at the asset limitations for a single person, generally in most states, a single person needs to be spent down to $2,000 or less of resources. When we look at the assets of the community spouse, if we're dealing with a married couple situation, these assets can range anywhere from $25,284 up to $126,420. So depending on if you're in a state that will divide the assets in half as of the snapshot date or the first period of institutionalization, that's going to determine if the married couple, the well spouse, is able to keep the maximum or if it's one half of the resources. If you have questions about that, feel free to reach out to me after the webinar with any questions. When we look at the income limitations and we're talking about a married couple, the community spouse can always have unlimited monthly income. If we are looking at the monthly maintenance needs allowance, this is going to be the amount of income that the community spouse is able to shift from the spouse that is in the institution over to the well spouse if the well spouse does not have enough monthly income to meet their needs on their own. So a lot of people will look at, especially if you're new to this industry, they'll look at the monthly maintenance needs allowance and they think that that's the maximum amount of income that can be generated for the community spouse, but that is not the case. The community spouse can have unlimited monthly income. So what if your married couple has excess assets and they have too many assets that they would not qualify for Medicaid? Well, then we are looking at developing a Medicaid eligibility plan, and this can range from improving non-countable resources, such as making home improvements, purchasing a new car, purchasing prepaid burial policies, paying off credit cards or other debt. And then if there's money left over, we can consider purchasing a Medicaid compliant annuity that complies with the Deficit Reduction Act of 2005.
So real quickly, I'll just add on this slide that, at the very, very top, if you have non-exempt or counted assets, then one of the strategies is probably the first strategy you look at is spending down and converting a non-exempt asset into an exempt asset. So that's just another way of saying the same thing for the first item on that previous slide.
Yes, thank you, Mark. So if we look at what a Medicaid compliant annuity is, this is going to be an immediate annuity, which means that it is in payout status. So an immediate annuity is going to make either monthly or annual payments, and it is not a tax-deferred annuity. A tax-deferred annuity is going to have cash value, and that is always going to be considered an asset for Medicaid planning purposes. So it needs to be an immediate annuity because we are converting countable assets into an income stream by using an immediate annuity that is considered a Medicaid compliant contract. So most people believe when they look at what language must be contained within an immediate annuity contract, that it has to have all of the language that you're seeing in blue, meaning that the annuity must be irrevocable, non-assignable, actuarially sound, make equal payments with no deferral or balloon payments, and then we must name the state Medicaid agency as the primary beneficiary unless there's a community spouse or a minor or disabled child. But most people don't realize that if we're dealing with retirement accounts, the retirement account annuity does not need to contain all of this language.
And one thing, let me just add before, if you want to go back, Amber, just for anyone taking notes, the third requirement for a Medicaid compliant annuity, that it be actuarially sound. What that means is that's just a very, very fancy way of saying that the annuity cannot be too long. Further meaning, it cannot be in an annuity that's in payout status or in payout mode that would be longer than an individual's actuarial life expectancy. It can be shorter, but it can't be longer. So actuarially sound just means the annuity can't be too long.
Correct. Thank you, Mark. So if we look at the different types of assets that can be used to purchase a Medicaid compliant annuity, it's really any type of liquid asset that can be converted into cash in order to purchase an annuity. So we can use money that's sitting in checking, savings, CDs, brokerage accounts, qualified accounts, or if your clients have existing annuity contracts, we can also do a 1035 exchange into a Medicaid compliant annuity. But we can do even better when we're dealing with qualified or retirement assets when we're funding the annuity. So there are different rules for an IRA annuity versus a non-IRA annuity, and we're going to look at the language that was actually contained within the Deficit Reduction Act of 2005. And Mark, if you wanted to kind of take the lead on this one, that'd be great.
Sure. So if you're looking at this slide, it's actually an excerpt from the actual federal statute dealing with annuities. And so one requirement of any annuity for Medicaid planning purposes, so no matter what, one requirement that's going to be there for any Medicaid compliant annuity, whether it's a non-IRA annuity or an IRA annuity, is that the beneficiary of the annuity contract has to be the state Medicaid program of where you're applying. That's automatic. That's always going to be the case. The only time that the state is in a second position in terms of being beneficiary is if there's a surviving spouse or a blind or disabled or minor child. And I'd have to read the statute to make sure I have all those exceptions. But the key one is a surviving spouse, because a lot of what we're going to talk about for this presentation is about planning, Medicaid planning, Medicaid crisis planning for a husband and wife where one of the spouses need care. So one requirement, doesn't matter what kind of annuity, IRA or non-IRA annuity, you're going to have to name the state as the beneficiary, but surviving spouse is in a higher priority. Then if you look down the statute a little bit further, it mentions that there's going to be a transfer of assets, meaning a gift or an uncompensated transfer, and then you're going to have a penalty period with just about almost any action that you take with respect to an annuity, unless the annuity is inside of a Internal Revenue Code section 408, meaning IRA, or 408A, Roth IRA, type of qualified account. So this is why IRA annuities have different treatment than non-IRA annuities. If it's a non-IRA annuity, that is where, as that previous slide showed, if you look at the very, very bottom of this slide, you'll see the language. The non-IRA annuity, if you're going to purchase a non-IRA annuity and make it in an immediate annuitized in payout mode contract, an annuity, then it has to be irrevocable, actuarially sound, non-assignable, non-transferable, with equal payments, no balloons or deferrals. And that language is right at the bottom. So there's the statute itself treats IRA annuities different than non-IRA annuities. So that's the whole purpose of why we're providing you the statute. That's the law, and the law distinguishes between the two. So next slide, Amber. So what we're really focused on, and what we're wanting to focus on with this presentation, this webinar, is the IRA annuity. And everything highlighted in yellow is what pertains to an IRA annuity. So you're going to have to name the state as the beneficiary unless there's a surviving spouse. And it has to be, the annuity has to be inside of an IRA or Roth IRA. And then the other thing that we point out, and you're going to have to really know your state's laws here, but in blue you'll see that we've also said that the contract should be, the annuity contract should be irrevocable and non-assignable, so that it takes away the availability argument. So if we put the annuity into payout mode, we want to put it into payout mode where the state can't argue that, well, you could sell that annuity and you could transfer that annuity and get cash. We don't want that argument, so we still want the availability argument to be knocked down, so that if you purchase an IRA annuity, and an annuity within an IRA, and you make it an immediate paid out annuity, or you annuitize it, you still want to make sure that the contract is also irrevocable and non-assignable, so that they can't say it's available.
Correct. Yeah. So this is just kind of summarizing what Mark just explained. As far as an annuity that's purchased with pre-tax dollars or IRA dollars, we're going to consider this to be an IRA annuity, but it can be any type of qualified retirement account when we're referring to an IRA annuity. It must name the state as the beneficiary. However, the annuity does not need to contain all of the other language that we talked about. It can be structured longer than life expectancy because it does not need to be actuarially sound, and it does not need to make equal payments. And so we can consider using a balloon payment, which we will go over later on. So this slide is just, again, summarizing the differences between a non-IRA Medicaid compliant annuity, and this would be purchased with any type of non-IRA assets. So money coming from a checking, savings, certificates of deposit would need to have all of the language that you're seeing on the left-hand side. But the annuity that is purchased with any type of qualified assets or IRA dollars must name the state as the beneficiary. And like Mark explained, to avoid the contract being considered an available resource or having any value on the secondary market, it would need to be annuitized and likely have the irrevocable and non-assignable language in there. So when we talk about Medicaid crisis planning is typically pretty simple when we're dealing with post-tax dollars. So again, money coming from checking, savings, CDs, because the client can just go down to their local bank, they can get a check. There's not going to be a lot of tax consequences that we need to consider in that type of scenario. But Medicaid planning,
mutual funds, brokerage accounts. Now you have to liquidate the investments, the stocks, bonds, mutual funds, exchange traded funds, but that is all non-IRA money, and you just use non-IRA cash to purchase the Medicaid compliant annuity.
Correct, yeah. So planning is going to become a lot more difficult when we're dealing with qualified or pre-tax accounts, because we can not change ownership from husband to wife or wife to husband when we're doing Medicaid planning with qualified accounts, because transferring ownership of any kind of pre-tax account is going to create a taxable event. So what we're focusing on today is really the ways to plan with pre-tax dollars or with IRA dollars. So we're going to define what is an IRA or a qualified account. An IRA is an individual retirement account. This can never be a joint account. So a lot of times when we get intake forms, or if somebody calls me on a case, they'll write down that the clients have a joint retirement account, but that can never be the case when we're talking about an IRA or any of the types of qualified accounts that you're seeing on the screen, whether it be a 401k, a 457, a thrift savings plan, 403b, a thrift savings account. Any of these types of qualified accounts can only be in one spouse's name. It cannot be a joint account. They're going to be funded with pre-tax dollars, meaning that the money has never been taxed. So when the money is either withdrawn, ownership is changed, or the account is annuitized, there will be tax consequences that are triggered. Another thing that I'd like to point out is the fact that Medicaid planning and IRS planning or tax planning doesn't always coincide with one another. So I've had cases where clients are under the age of 59 and a half, where they will have to incur early withdrawal penalties from a qualified account, because that is an IRS rule that they will need to pay early withdrawal penalties on an account that with somebody that is under the age of 59 and a half. But Medicaid will, in most states, consider that account to be an available resource. So you need to consider the type of planning that we can do with an account where somebody is under the age of 59 and a half, and do not only tax planning, but also Medicaid planning to convert that into a non-countable asset. Mark, did you have anything to add on that?
No, the only thing I'll add is IRAs are section 408 of the Internal Revenue Code. Roth IRAs are 408A, like Apple, and those are the exact code sections referenced in the Medicaid statute we just looked at.
Okay, perfect. When we're talking about Medicaid planning and qualified accounts, each state is going to be different as far as how they treat qualified accounts for Medicaid planning purposes. So there are some states that will completely exempt the IRA and consider it to be a non-countable asset. If you're in one of those states, you're very lucky, because clients can have large IRA accounts and you can basically take that off the table altogether as far as qualifying them for Medicaid. But that's only a handful of states that completely exempt the qualified account. Other states will consider the IRA to be exempt if the IRA owner is receiving their required minimum distribution that they would have to take at 70 and a half, or if they're receiving systematic payments from the qualified account. And then there are the most number of states that will completely count the IRA as an available resource or an available asset for Medicaid planning purposes. It may be different in your state as far as how they treat the qualified account of the community spouse and the institutionalized spouse. So there are a number of states that will consider the community spouse's qualified accounts to be non-countable, but they will count the institutionalized spouse's qualified account as a countable resource. Medicaid planning is going to be most complicated in states that consider the qualified account or the IRA account owned by the institutionalized person to be an available resource or accountable resource. And most of the country treats qualified accounts this way. There's currently 40 states that consider the qualified account that is owned by the person in the nursing home or that's trying to qualify for Medicaid as a countable asset. What are the planning opportunities when the institutionalized retirement account is considered a accountable resource? And that's really the focus of today's webinar. We're going to be discussing 3 different options that clients would have to deal with the institutionalized spouse's retirement account. The first is to use a DRA, IRA annuity. The second option would be to use name on the check rule. And then the third option, which Mark will be talking about, will be the in-marriage QDRO. So what is name on the check rule? This is strictly a Medicaid concept. It is not an IRS rule. So the Medicaid concept of name on the check rule is that the income belongs to the person whose name is on the check. And I included the code section there that where you can find the name on the check rule within the Medicaid rules. So we need to stress that this is not an IRS rule. So you would never find in the IRS rules that the institutionalized person is able to transfer income over to the community spouse or the spouse that is at home in any IRS rules or regulations. So that's what makes using name on the check rule somewhat risky when we're talking about Medicaid planning and also tax planning. When is the rule used? It's going to be used when we have a married couple situation where the institutionalized spouse owns a qualified account or an IRA account that needs to be spent down in order to gain Medicaid eligibility. So our example here is a married couple. We have Joe and Mary. Joe is 78 years of age. After struggling with dementia for years, he's now in need of nursing home care. And Mary is 76 years of age and resides at home. So she's going to be considered the community spouse in this example. Joe has monthly income of $1,500 and his monthly nursing home bill is $6,000 a month. Mary's monthly income is $1,000 a month and she has a monthly maintenance needs allowance of $2,114 per month. Joe and Mary have been married for over 50 years, and together they have a home, prepaid burials, 1 car, and $350,000 of assets, of which the $250,000 consists of Joe's qualified account. So if we look at Medicaid planning with this couple and we're trying to determine how many assets need to be spent down in order to qualify Joe, the institutionalized person, for Medicaid, he would be able to keep his personal property, a prepaid burial plan, and $2,000 in most states of the $350,000 of assets. Mary, as the community spouse, is entitled to keep the home, car, furniture, and personal property, prepaid burial policy, and $126,420 of the $350,000 of cash assets. So when we're looking at subtracting the protected assets from the $350,000 of assets that they have, the total spend down amount in this case is going to be $221,580. This would be a pretty. Go ahead.
And so just another way of, what Amber said is, accurate, 100% accurate. Just another way of saying the same thing is what I like to call the $221,580,000. I like to call that the excess asset amount. Those are excess assets. And unless and until that amount goes down to zero, either by spending it down or purchasing an annuity or doing something with it, that there's no Medicaid for Joe, even though he's in the nursing home. So we have excess assets in this example of $221,580, and until the excess assets get down to zero, there's no Medicaid for Joe. So our goal is what can we do to remove that $221,580 and get it down to zero.
Mm-hmm. And it would be a pretty easy scenario if we were dealing with Mary, the community spouse, being the person that owned the qualified account, because then we're not talking about changing ownership of a qualified account or things of that nature. So we're really, the most problematic asset in this case is the fact that Joe, who is the person in the facility, is the one that owns the qualified account. And like I just said, the real problem asset is Joe's qualified account. So if we're looking at the most cost-effective, tax-efficient way to spend down the excess resources, like Mark said, and also qualify Joe for Medicaid, then we're going to be looking at several different options that these clients have. Option one is they could do nothing at all and they could privately pay. They're going to spend down all of their assets or go through all of the excess resources in less than 5 years. So based on Joe's longevity, they could run out of money and he could end up on Medicaid anyways. The second option would be to liquidate the institutionalized spouse's qualified account, pay all the taxes, and transfer the net amount over to Mary as the community spouse. They will pay all of the taxes up front. Go ahead.
In which case, number two, if that's what they did, and that Mary would still need to do a non-IRA Medicaid compliant annuity because they'd still be over assets.
Correct. Yes. The third option is to convert the institutionalized spouse's qualified account into a DRA IRA annuity. The fourth option would be to use name on the check rule. And the fifth option is to implement in marriage quadro. We go through option number 3, which is converting the institutionalized spouse's qualified account into a DRA IRA annuity. We would convert the $250,000 that is currently in Joe's qualified account, and we would put that into a tax qualified or an IRA DRA compliant annuity. And in order to avoid a taxable event, since Joe is the owner of the qualified account now, he would also need to be the owner of the DRA IRA annuity that we would set up. With Joe being 78 years of age, his Medicaid life expectancy is 9.33 years, so 111 months. If we were to stretch out the term of the annuity over his full Medicaid life expectancy, the monthly payout on the annuity would be around $2,300. And you see that the total payout, $255,000 and some change, is going to be slightly more than what is put into the contract. That's just a small amount of interest that would be paid on the annuity contract in addition to the return of principal. By using a DRA IRA annuity in the name of the institutionalized person, we are utilizing a like-to-like transfer, and Joe would be the annuity owner, the annuitant, and the payee of the contract. The income generated off of the annuity would be considered income that belongs to Joe, since he would be the payee of the annuity. And Mary, as the community spouse, would be able to be the primary death beneficiary of the DRA IRA annuity before the state Medicaid program. So there is the exception if there is a community spouse or a surviving spouse that they would be able to be named as beneficiary before the state. If we look at the copay amount that would be that would result from doing this type of plan, we see that Joe's income on the right-hand side is going to be around $3,800. We calculated that by adding his Social Security income of $1,500 and also the annuity income of $2,300 to get $3,800 per month. We see that Mary is short around $1,114 per month. So there would be a shifting of income under the monthly maintenance needs allowance over to Mary. And then he would also have around $50 for his personal needs allowance. So the copay in this scenario would be $2,700 $636 per month. We look at an alternative scenario of using a balloon style annuity instead for Joe. We're referring back to the fact that an IRA, a DRA IRA annuity does not need to have equal payments. So we could technically use a balloon style annuity to reduce the amount of income that's generated from the annuity and decrease the copay that Joe is currently paying to the facility. So with Joe being 78 years of age, his required minimum distribution for IRS purposes is going to be $12,315 per year. So that's just over $1,000 per month that we would need to generate from the balloon style annuity so that he's able to meet his required minimum distribution. So you'll see by putting the same amount, the $250,000 into a balloon style annuity over the full life expectancy, then in months 1 through 110, the monthly payment from the annuity is going to be $1,117 per month. And then there's going to be a large balloon payout in month 111 at $132,397. Total payout is going to be very similar to the level pay annuity that we just illustrated. But the main thing that you need to take away from this slide is the fact that we can do a balloon annuity to reduce the amount of income that's generated off of the annuity, which will also reduce the copay to the nursing home. We can also look at shortening the term of the annuity. We don't necessarily need to do full life expectancy of 111 months. If Joe was still alive when the balloon payment is scheduled to pay out, we can always roll that into another annuity without him actually receiving that balloon payment and causing a taxable event or causing an asset problem for Medicaid planning purposes.
And remember, because this is an IRA annuity and an annuity with IRA dollars, it can be longer than Joe's life expectancy or even Mary's life expectancy. So it does not have to be actuarially sound. So this is one of these requirements that's for non-IRA money. It has to be actuarially sound, which means it can't be too long. It has to be at someone's life expectancy or shorter, but it can't be longer. Here, it can be shorter at life expectancy or longer. So there's just more planning opportunities of what to do with this money.
Okay, so if we look at the copay amount in this scenario by using the balloon annuity, we see that Joe's monthly income in this case, instead of it being $3,800 per month, it's going to be $2,617 by adding his Social Security income of $1,500 plus the annuity income that's generated from the balloon contract. There's also going to be a shift still over to Mary of $1,114 per month and a personal needs allowance of around $50 a month. Mary's income in this scenario is not changing at all. We're just trying to reduce the amount of income that is generated for Joe because he's going to be the payee of the DRA IRA annuity. So instead of the copay being around $2,600 per month, like we saw in the first scenario, we're now reducing the copay down to $1,453.35 per month by using the balloon style annuity. If we now look at option number 4, name on the check rule, we would do the exact same plan as far as annuitizing the $250,000 by purchasing a DRA IRA annuity. Again, Joe would have to be the owner of the annuity to avoid any kind of taxable event. It needs to be a like-to-like transaction. And again, if we use a level pay annuity, the income that's generated off of the annuity is going to be $2,300 per month. If we use the name on the check rule, instead of having Joe be the payee of the annuity, we would instead name Mary as the payee of the DRA IRA annuity. So really the only difference between option 3 and option 4 is who is named as the payee of the annuity contract. Joe is still going to remain the annuity owner so that there's not a taxable event that occurs, but Mary is going to be the payee that's named on the annuity application. Also, Mary is going to be the primary death beneficiary of the annuity before the state Medicaid agency. In this scenario, if we look at what Mary's monthly income would be by adding her Social Security income of $1,000 plus the annuity income, because we named her as the payee, she now has monthly income of $2,300 or $3,300, excuse me. So her monthly income exceeds her monthly maintenance needs allowance at $2,114 per month. So she no longer has a shortfall. So she's not going to receive any of Joe's monthly income in this scenario. Joe would only have his Social Security income of $1,500. He's not shifting any income over to Mary, but he still gets a $50 personal needs allowance, and his copay in this scenario would be $1,450 per month. The advantages of using name on the check rule was that we were able to secure immediate Medicaid eligibility for Joe. Mary has monthly income now of $3,300 per month. They paid limited federal income tax on this transaction because Joe remains the owner of the annuity, and we're just directing payments over to Mary. So their Social Security income and their Medicare premiums would not become taxable. If Joe predeceases the term of the annuity, Mary in this example would also be the primary death beneficiary. The disadvantage of using name on the check rule is that it is a somewhat risky strategy. There is no guarantee that the state Medicaid agency is going to actually consider the income generated off of the annuity to belong to the community spouse. And we're finding that more states are starting to challenge using name on the check rule. So instead of doing option number 4, we're now going to move on to using option number 5, which is in-marriage QDRO, which Mark is going to walk us through.
All right, thanks, Amber. So most of us are familiar with the term or have heard the term of QDRO. QDRO stands for Qualified Domestic Relations Order. Domestic relations, refers to an area of law that I don't practice in, and I'm grateful for that. Domestic relations means family law. Family law means divorce and legal separation and those types of legal cases. But the whole idea with qualified domestic relations orders is that it's a way to move money from, and I should say tax deferred money, whether it's in a plan like a 401k or a 403b or a pension plan, or even an IRA. It's a way to move pre-tax dollars from one spouse to another spouse without any income tax consequences. And the reason for that is so that property division can be equal, so to speak. If you use the classic example of there's one spouse who is the breadwinner, the other spouse is a homemaker, and these two spouses decide that it's time to no longer be married. Well, if there's a $2 million 401k and we have to take that out, $1 million out to make the homemaker spouse, in quotes now, whole, the problem is that the homemaker spouse is going to get $1 million less the taxes. And so, hence we have the the QDRO, the Qualified Domestic Relations Order language that allows a plan like a 401k plan or an IRA to be divided and moved into the name of another spouse with no adverse immediate income tax consequences. So at the end of the divorce, we can still have $2 million in a retirement account, but instead of $2 million being in one account in the name of one spouse, we're going to have $1 million in one account in the name of one spouse and $1 million in the name of a separate retirement account for the other spouse. So QDROs just allow division of tax deferred accounts so that spouses can receive that without any tax consequences. So we often think of QDROs in the context of divorce cases and legal separation cases. When we do Medicaid planning for a married couple, we really don't want to be advising or recommending divorce. If sometimes there's no other way, there's no other alternative, there's just, it is the best answer. But I think all of us would agree generally that divorce and legal separation should be an item of an option of last recourse, and we don't even have it as part of the presentation for Joe and Mary. That's how adverse we want to be to having to tell people they'll just get married. That'll make your life better and easier. So the whole idea of in-marriage QDRO is that we want to do a QDRO within the marriage. We want the marriage to remain intact, not be dissolved or not be separated, and we want to do a QDRO. Okay, it's usually going to be from a nursing home spouse to the non-nursing home spouse or the community spouse. So go ahead, Amber, and we'll go through the slides. So Amber and I recently did a presentation and on this topic, and we both had different names for the same type of assets. Qualified accounts, whether it's an IRA or 401k, I call them loaded guns, and loaded guns are dangerous, and you have to be careful with how you handle them. Amber called them a ticking time bomb, and again, if that's what you have to be careful with it and know what you're doing. So we tend to think of these as untouchable assets because they're so dangerous. They're ticking time bombs for the tax consequences. But this may be an alternative that may be very worthwhile for your clients and certainly needs to be considered in a case like Joe and Mary. Next slide, Amber. So the in-marriage QDRO concept applies to ERISA-based retirement benefits. ERISA is the Employment Retirement Income Security Act. It applies to these types of benefits or plans, and we've got a list for those on the slide here. So this is what is really covered by the ERISA statute and where QDROs, Qualified Domestic Relation Orders, that's where the law really truly applies. So we've already talked about, next slide, Amber, we've already talked about what a QDRO is, and the way that you get a QDRO is that it has to be an order that's signed by a judge or a court that's overseeing two parties there, and they're going to be, it's a married couple, and they're whether it's in the context divorce, legal separation, or otherwise, the court's going to sign an order, and the order is going to say a certain percentage of this spouse's retirement account is going to go to this other spouse, and we want it's going to be done tax-free pursuant to this court order, Qualified Domestic Relations Order. So the language is, there's the plan participant, so that's the spouse whom the benefit, the retirement benefit or the plan belongs to, and then there's this alternative payee, the alternative payee being the other spouse. So again, this is it's mainly a way at this point to divide property in an even-handed manner, and at least that's now how certainly it's used now, to divide property in an even-handed manner without tax consequences. So, you know, just you can Google and all the information you need and want about QDROs. It's there. Traditionally, you know, you think of QDROs and you think, oh well, there has to be a divorce and there has to be a legal separation. Next slide, Amber. But if you really get into the minutia and into the detail of the ERISA statute, and we look at the definition of the term alternate payee, you know, we refer to spouse, former spouse, child, but if you focus on spouse, you know, it doesn't say that a spouse who is, you know, getting in a divorce case. It doesn't say it's a spouse who's in a legal separation case. The statute simply says spouse. So because it simply says spouse, this is precisely what allows for a QDRO to be used within a marriage. It doesn't have to be used at the end of a marriage or the conclusion of a marriage. It can be used at any point during a marriage. And so this is what's opened the door to the concept of in-marriage QDRO. Now, you still have to go to court. You still have to petition the court, ask the court to sign the order in order to do the tax-free rollover to the alternate payee who can be a spouse. And because it doesn't have to be a divorcing spouse or a legal separating spouse, it just has to be a spouse. So this is the sort of thing that opens the door to allow for in-marriage QDRO. Next slide, Amber. So the title says, an uncommon application. You know, most people who are familiar with the term QDRO or who have heard it think that a QDRO has to be pursuant to or incident to a divorce or legal separation. And again, just based on the reading of the statute, that's not the case. It's where it's been historically and most commonly used, but there may be reasons, many reasons, both for Medicaid reasons and pure blown estate planning reasons, which is outside the scope of the presentation today, as to why spouses may want to do an in-marriage QDRO, just purely for planning reasons. And there are different, again, applications and reasons outside of just Medicaid as to why spouses may not want all of their money tied up in a 401k plan. So you know, certainly thinking a little bit differently, but the opportunity under the law is there. So go ahead, Amber. So what about IRAs, individual retirement accounts? Again, these are governed by Section 408 of the Internal Revenue Code. Roth IRAs are 408A of the Internal Revenue Code, and they are not ERISA-based plans. So I'll repeat that. IRAs are not ERISA-based plans. And so that alternate payee language that we just looked at, there's nothing similar in any statutes for 408A and 408A regarding alternate payee and the concept of doing a quadro that's inside the marriage. So these are just some bullet points of what IRAs are. Next slide. And so so this is more of about IRAs, but the language, the statutory language governing IRAs in 408A and 408A is it says that you get a quadro pursuant and incident to a divorce and legal separation. That's what most people think. Well, that's the way it is. So IRAs don't have the same language that 401ks have or a pension plan has, because they're not governed by ERISA. So if all we have are IRA plans and we need to get money moved from one spouse to another tax-free, and we don't want a divorce, what's the methodology? What's the planning that may have to be done to get to point A to point B? So go ahead, Amber. So this is what we just talked about. ERISA plans are different from IRA plans. And so what do? So one planning option, one thing to think about is that for the spouse who has the IRA in his or her name that we're looking to get to the other spouse, we have that spouse create an LLC, a single member LLC, and then that spouse through the LLC creates a solo 401k plan. Well, solo 401k plans qualify as ERISA governed plans. And then we do a tax-free direct rollover from the spouse's IRA to the spouse's solo 401k plan. And now that we have a plan that's subject to ERISA rules, we can now go to court and petition the court and ask the court to give us a quadro that is going to be within the marriage. So here's an example. I'll turn it back over to you, Amber, and we can work through the example together with how in-marriage quadro could be used to help out our Joe and Mary clients.
Yeah, so the case facts are going to be exactly the same as what we were dealing with before. There's around $100,000 of non-qualified assets, and then Joe is the institutionalized person, and he owns an IRA that is worth around $250,000. And we're looking at the best way, if we're not going to use name on the check rule, to implement in-marriage quadro and shift the qualified account over to Mary, the community spouse.
So the planning goal in this case, is to really get that IRA, that $250,000 IRA, to be where it's now in the name of Mary rather than Joe. So as we explained before, there's a little bit more of legal planning with this. We have to create an LLC. We have to establish a solo 401k plan. We have to do a rollover from IRA to solo 401k. And then we have to go to court and get a court order allowing the the solo 401k to be transferred over to the in this case it would be the community spouse. But now, if we did all that, you would have an IRA that's in the name of the community spouse. If you have an IRA in the community spouse, you may be in a state where the retirement assets of the community spouse, or in the name of the community spouse at least, are exempt assets. So now you don't even need to annuitize or do anything with that asset. You've just converted that asset from a counted asset in Joe's name to an exempt asset because it's now in Mary's name, and you've done it income tax free. And that, I think, Amber and I would both agree that if your state allows that, that's probably the best result, because then Mary can access that money whenever she needs it or doesn't need it, except for the required minimum distribution. So that's kind of how we think about it and how it could work. If we get the annuity, if we get the IRA into Mary's name and your state doesn't allow the community spouses retirement accounts to be exempt, then we can do a DRA IRA annuity where we can break all these rules that normally we think we have to follow, but we don't have to follow, because the annuity doesn't have to be actuarially sound, and we can have deferred payments, we can have balloon payments, we can have a whole bunch of stuff. So there's a lot of ways to protect that IRA once it's in the name of the community spouse, which is one of the values in married couple Medicaid planning, where if the nursing home spouse has a larger IRA, if we can get that into the name of the community spouse, I think our options to do good and to do better work for our clients are enhanced by doing that.
Okay, awesome. So it looks like we do have a couple of questions here. We only have a couple of minutes left. Mark, this question is probably one that you can answer. This person is asking, how many in-marriage quadros have you done in the last 2 years, and how did the court react to
Amber,
being
I can't hear you.
Can you hear me now? Can you hear me?
Now I can, yeah.
Oh, okay. Well, I'm sorry about that. We have a question here about how many in-marriage quadros have you done in the last 2 years, and how did the court react to being asked to sign the quadro?
I think we've done, been involved in over 15, and the way that we try to go in doing these is so that we do encounter as little resistance as possible. We structure the petition as a joint petition, both by husband and wife, or by each spouse within the marriage, and each spouse is represented by separate independent legal counsel, and we're just filing the petition. And in most cases, the courts are not requiring a hearing. We're finding statutes and laws within the states that we've done these that hopefully there is these types of statutes. Not every state has them, but that should allow married couples to structure their financial affairs and the ownership of their assets in any way that they choose. Now, the reason for having both spouses having separate independent legal counsel is so that the judge can be confident that each spouse has been advised of the advantages and disadvantages, the risks and rewards of doing this. And I think if, generally our experience has been, if you do it right, and you're not even going to have a hearing. The judge is just going to say, this is what a married couple in my state wants to do. They're both represented by counsel. They want to structure their property a certain way. They need my help. I'm going to sign the order. Perfect.
Okay. We have some other questions here. One is, when using name on the check rule, which spouse receives a 1099 for the distributions? And it would be the owner of the annuity that is receiving the 1099. So in our example, if we annuitize the qualified account of Joe, and we do that through a like-to-like transfer so that he remains the owner of the IRA annuity, then he is also going to be the spouse that receives the 1099 at the end of each year. So it will still be considered his taxable income.
Amber, that's a reason you'd say this strategy is becoming more and more risky as time goes on.
Correct, yes. We do have a handful of other questions. I will reach out to you personally to answer them because we're out of time. We will be having another webinar next month, and the topic will be focused around using social media to fill seminars. We're going to have a guest speaker, Jim from BAMBiz, and that will be in the middle of November. So feel free to look on our website for more information on that. I want to thank everybody, and thank you, Mark, for being a part of today's webinar, and I hope you all have a great rest of your week. Thank you.
Thank you, Amber, and thank WealthMerge, and I thank everyone for attending.